Hello, and welcome to this week's edition of Smart Counsel for Lunch. My name is Sean Downing, and I'm an attorney here at the law firm of Samuel, Sayward Baler. We're located in Dedham, Massachusetts, and we specialize our practice in the areas of estate planning, elder law, trust and estate and administration, and probate. So this week, I wanted to talk about a question that we get a lot, which is what happens if I don't have an estate plan? Um, It's definitely something worth thinking about because it might not be exactly what you think would happen. A lot of people think, oh yeah, it just goes to the people I wanted to go to. That might not be the case. Um, First, I want to mention about what happens if you have minor kids or even a disabled child who you have guardianship over. Now, the law gives you the ability to appoint a successor guardian, but you have to do that in your will. So if you don't have an estate plan, you wouldn't have that. Now, in that case, if the child or the person you have a guardianship over, if they have a second legal guardian, that person would automatically step in and have the power to continue as guardian. However, if that person also passes away with you, or if no such person exists, then it just goes to court, and it's the standard is the judge gets to decide who has the best interest in being the guardian over that child or person who has a guardianship over them. And that can be a fight. Especially if it's grandparents on both sides, it can get messy. So it's a really great idea to name guardians in your will just to make it nice and clean who gets to become guardian if you're unable to. Now, even if you don't have kids, the big question is what happens to all my stuff? If you have things on beneficiary forms, they will pass to the person named on the beneficiary form without probate. But some things, such as your real estate, you can't do that a beneficiary form. So it goes through probate. And there's something called intestacy laws. And that's just the series of laws that say what happens to someone without a will if they die with probate assets. Now, if you're a married person and you have children, and all of the children are, of the marriage, then it kind of works the way you think it does. Everything would pass to your spouse. And then at your spouse's death, everything passes to your kids. So that's the one that kind of makes the most sense. There's some interesting little quirks if you're not in that situation. So if you're a blended family, children from previous relationships get a little cut at your death. Even if you have a spouse and you have kids together otherwise, it's going to start splitting off and going. And it's just a fraction that's determined by the law. You can change that if you have a will or a trust, but if you don't have either, it's whatever fraction the law says. Similarly, if you don't have children, but you are married, and your living parents will also get a cut and won't all go to your spouse. Again, that's determined by the law. It's just a fraction, but that can be changed with a will or trust. So I guess at the end of the day, the best advice is, definitely see an estate planning attorney to make sure you have at least a basic will set up. Particularly if you have minor children or someone you have guardianship over. Talk to a estate planning attorney. Often a trust makes sense, but it's not for everybody, depending on their situation, the amount of assets they have, that kind of thing. So I highly recommend that. I did also want to do a little shout out. On June 9th, I'm going to be doing a seminar at our Dedham office, and it's all about estate planning considerations for non-traditional families. So that's 6 o'clock on June 9th. I'd love to see you there. If you would like to join, please sign up on our website at ssbllc.com. And I hope to see many of you there. Otherwise, have a great end of May and looking forward to the summer and seeing you around the office. All right, have a good one.